So good afternoon, everybody. I hope that you can all see me. Adeyemi, can I ask you to confirm that we can continue speaking and continue with our panel, if that's okay? Excellent, fantastic. Well, welcome everybody to this panel 3 of the African Arbitration Association's conference, which will focus on the current initiatives and proposals on ISDS reform at multilateral levels. Before we start, may I remind you that there is a French translation available for the panel. So there's an interpretation button at the bottom of your Zoom screen. And if anyone would like to use that translation, then please go ahead. My name is Lisa Bosman. I am the Executive Director of the International Council for Commercial Arbitration, ICA, and I'm also privileged to serve on the board of the African Arbitration Association. So this session on ISDS reform, the reform of the system of investor-state dispute settlement, was conceived as one of 2 sessions at this conference addressing ISDS reform. This panel 3 is intended to give a briefing on some of the action that has already been taken or is currently being considered by global and regional bodies to reform the current system of ISDS. Panel 4, which follows shortly at the end of the day, will focus more explicitly on African perspectives on current ISDS reform options. So to provide you with a very thorough briefing, we've gathered 4 eminent practitioners who have all in their different ways been at the coalface of ISDS reform discussions and implementation. First, we will hear from Anna Joubert, who is the current secretary of the UN Commission on International Trade Law, UNCITRAL. Anna oversees the complex interstate discussions that are currently taking place in UNCITRAL Working Group 3 on ISDS reform. Next, we'll hear from Aïssatou Diop, who is legal counsel at ICSID, as you know, the institute that currently and historically administers the largest number of ISDS disputes annually. Now, ICSID is currently rounding off a multi-year consultation process to reform its own arbitration rules, aimed at modernizing those rules and responding to some of the criticisms made of the ISDS process. Our third speaker today is Patience Okala, who is the legal advisor for the Nigerian Investment Promotion Commission. Patience's work as chief BIT negotiator for Nigeria in reimagining the content of new generation BITs is regularly cited as a potential new direction for investment protection in Africa and possibly more widely. And finally, we'll be briefed by Lawrence Ngugi, who is the registrar and the CEO of the Nairobi Center for International Arbitration, who will focus on recent developments in ISDS in the Eastern African region, including some new and some proposed investment protection practices and BITs. Now, there'll be time for Q&A at the end, and I encourage you all to post your questions either in the chat function or in the Q&A function while the panelists are speaking, and then I'll gather those questions and direct them to the most appropriate panelist at the end. Each speaker has 15 minutes, and so with that, I'm going to hand over to Anna. Please go ahead.
Thank you very much, Lisa, and at the outset, I'd like to say how grateful and glad I am to be joining my fellow panelists on this panel and to be given the opportunity to present the work that is going on in UNCITRAL on reforming the investor-to-state dispute settlement system. I will share my screen so that I can share my presentation with you. Hopefully it works. Yes, it does. Here we go. So I would like to present briefly what UNCITRAL is currently doing in terms of reforming investor-to-state dispute settlement. This is a mandate that has been given to our Working Group 3 in 2017. And it's a broad mandate, and it doesn't have a particular end date or a pre-agreed end product. but it's a broad mandate to work on possible reform of investor-state dispute settlement. It's a mandate that was constructed around 3 stages. And the first 2 steps of this mandate we have already passed, and we are now in the 3rd and last phase of the mandate, which consists in actually developing the reform options that will then be packaged together and brought to the deliberation of states or to the deliberation of the UNCITRAL Commission, I should say, for its adoption. And what I would like to highlight briefly is that this mandate really focuses on a number of very specific aspects. One and very important one, I think, in the context of this conference, is that contrary to other areas of work of UNCITRAL, here the Commission insisted on the fact that the deliberations and discussions and decision-making should be government-led. So we're not focusing on expert participation as much as we do in other working groups. However, the Commission had also called on inputs and expertise from high-level experts from representing all stakeholders. The mandate also requires full transparency on what is being done in Working Group 3. And of course, as in many places in the United Nations, the deliberations on ISDS reform are consensus-based, which may make it less clear for those who are looking at it from the outside as to what is the progress that is being made. But I hope that at the end I will be able to reassure you on the fact that we have made very important progress, particularly since starting the 3rd and last phase, and that we have moved ahead on a number of the reform options that have been put on the table. So we have received in this working group increased participation by states. We have more than 400 delegates here. You see a picture from another time, like another life, when we still had in-person participation in meeting rooms in Vienna. Nowadays, we have an empty meeting room and we have 400 plus people joining online. There are a number of benefits to that because, of course, it allows more participation. But on the other hand, it makes it more difficult, as you can imagine, to find some consensus around a cup of coffee or a nice Viennese cake. So we have about 100 delegations turning in at each of these sessions, state delegations, and we have a number of observer organizations, whether international organizations or NGOs, participating actively in the deliberations. What are we working on? And I'll go a little bit more into the detail here. We have 2 main streams of work. We have a first stream that is a strictly procedural, and let me start from the bottom here. There is agreement that a number of issues that are addressed generally in free trade agreement investment chapters, such as means to address frivolous claims, to prevent multiple proceedings, to address reflective loss, to allow states to make counterclaims, to regulate security of costs, to regulate third-party funding, or to provide for tools and means for treaty interpretation, that these procedural rules reforms will be, I would say, bundled together in order to allow states to apply them to existing treaties, but also to future treaties, to address them in rules or to address them in domestic codes in the way they wish to. The other element of this procedural work stream is a code of conduct for adjudicators and judges, which is being developed jointly with our friends and colleagues from the ICSID Secretariat, and where we have again made substantial progress insofar as we are now at a second draft of this code of conduct that will go for discussions at in the month of October of this year by the working group. We have also prepared several papers and had already some preliminary discussions on selection and appointment of arbitrators and adjudicators. And we have also put forward some papers and will have a forthcoming discussion of the means to foster ADR mechanisms, to give them more prominence, and to also develop best practices, probably in the form of a model law on dispute prevention. And then we move to another stream, which is the structural work stream. And here we're working, and it's important to say that we are working in parallel on these two streams of reform options, so as to make sure that we do not give preeminence to one over the other. So if there's a really quite strict alternation of the way we are addressing or we are scheduling work on these different streams. In this structural stream, there is a first project that I hope I'll have a little bit of time to enter into, which is the development of an advisory center patterned on the advisory center that already exists and operates for WTO disputes, and where the aim is to assist and also represent states, particularly those that have no constituted teams or that have very little means to defend themselves adequately in investor-state disputes. The second element of this structural work stream is the to set up an appellate mechanism. It's not yet clear whether this will be an integrated second tier mechanism that would fit with a multilateral permanent investment court as is being proposed by a number of states, or whether it will be a standalone appeal mechanism. It's also not clear whether it will be a mechanism or a standing body, but all these options are now on the table, including with some feasibility and some wording and drafting provisions. And last but not least, there is, of course, the way to deliver on this reform. And here we are looking into a multilateral instrument to deliver on the reform that would be patterned on the existing Mauritius Convention, insofar as the Mauritius Convention applies not only to future treaties, but also to the existing 3,000 something treaties that most of which do not have these very elaborate provisions that are being envisaged in the reform package. So through the multilateral reform package, states would be able to apply to their existing treaties all the different reforms options they want to sign on to. And the second element of this multilateral instrument is that it will be flexible in the sense that there will be core elements to this multilateral instrument that will apply to everybody who signs on to the multilateral instrument. But then there will be different protocols or different elements of this reform package that will be, I would say, a la carte, where states can choose whether they want or don't want to take part. For instance, let's take the example of the Multilateral Advisory Center. Not all states will want to or will wish to or will have a reason to become members of the Advisory Center. So the Advisory Center, while being established through under the multilateral instrument, will not necessarily require that everybody becomes a member to it. So how does that look like? I like to use this little house to show that there is a real expectation of coherence in what is being constructed. And what it would look like for claimants or for disputing parties is that one of the doors that is already there, which exists, is the investment arbitration, whether under ICSID or UNCITRAL rules. This door will remain in place because a number of countries have made it very clear that they wish the reform to build on the existing ISDS system. Some of the states that favor a state-to-state procedure will also continue to allow entry into the ISDS broader court through the state-to-state procedures. What the EU is proposing is an entrance with a first instance investment court. And then a few countries are insisting on exhaustion of local remedies, and domestic courts would continue to be the favored entry for disputes brought by investors against that. But what is really novel is what is happening at the second story of this little house, which is the establishment of an appeal. And this appeal would apply both as a standing appeal body or an appeal mechanism to the existing investment arbitration system. And this is really where we are working very closely with our colleagues from ICSID, because we need to make sure that it will work with the ICSID Convention. The purpose is not to scrap the ICSID Convention and say we start from scratch, but it's really to make sure that it works with this existing system. It will also work as a second instance for the investment court that is being called upon by a number of states. And it will work as an appeal mechanism for state-to-state disputes as well. This was further confirmed by a number of states that are interested in this feature at the last session of the working group. In addition to that, you will see two aisles to this house, which are the strengthening of ADR mechanisms and stronger support to disputing parties through an advisory center and dispute prevention policies. What is constituting the roof and the overall coherence of the system is really to put state control and state ownership of their treaties in the middle or at the forefront of this new this new construct, and make sure that whatever is being developed allows full control and interpretation by the states of their treaties. And we all know, except that it's an elephant in the room, that it may have an impact on substantive standards, but we haven't decided so far, or we have been very clear in not addressing these substantive standards at all. But we all know that they are there, and that presumably a number of these options will have an impact on the substantive standards. So what will it look like as far as the floor plan is concerned? All of these procedural issues that I have mentioned before will be available to and will be applicable to future treaties and to the 3,000 existing treaties, and will feature as such in the broader convention, which will be the host of this multilateral ISDS reform agenda. And let me just in closing invite you to join our forthcoming session, which is going to be a resumed session on the 4th and 5th of May 2021 online in Vienna, where we're going to discuss what has really been a very important element to be developed. It is our work plan, and most importantly, the time when we will conclude this reform effort. And we have set this, the member states have set this to the Commission session of 2025, which leaves us basically 3 years to develop all these reform options, and that's quite a lot. But we are working on it steadily, and with the help of our member states, we hope that we will be able to deliver first on a code of conduct that will come to the Commission in 2022. In 2022, In 2023, we hope to present all the procedural reform options. In 2024, we will bring the institutional, structural reform options, and the entire package should be agreed in 2025. So that's where we are. We believe strongly that there is a very important contribution on the part of African states that we are already receiving, and we are very happy for the very strong engagement of both Francophone and English-speaking African countries. But we're very conscious of negotiations that are taking place in the region, and where we hope that we will be able to ensure that there is a complete coherence between what we're doing and what these regional groupings and others are expecting from us. So Lisa, I hope I haven't been too much over time, but it's quite a mammoth effort, and it's of course difficult to go beyond the teaser in 15 minutes. Thank you.
Thank you, Anna. It absolutely is mammoth. It's fascinating to see how many different tables that you are busy working on at the moment at the same time, but good to see that there is a coherence to the whole. So with that, I would like to turn to Aissatou Diop, who can give us some sense of the very intense and very extensive consultation process that you've been through in order to come up with reform proposals for the ICSID arbitration rules. Over to you.
Thank you, Liz. I'm going to share my screen first. Is it sharing now? Yes, okay, good. Thank you. Good morning, good afternoon to everyone. I thank the African Arbitration Association for organizing this important conference and inviting ICSID to participate in it. I thank the organizers, Dr. Baruti, Chief Adebayo, the moderator of my panel, Liz Bozeman, and of course my co-panelists. My task today is to give you a brief overview of ISDS reform at ICSID with a focus on the current rule amendments. But I want to begin with some context for those of you who may perhaps be less familiar with ICSID. ICSID is one of 5 organizations that make up the World Bank Group. The other 4 are IBRD, IDA, IFC, and MIGA. ICSID of these is the only non-financial institution. So its mandate is to provide facilities for the settlement of international investment disputes. ICSID was created by the ICSID Convention, also referred to as the Washington Convention, in 1966. And in terms of structure, it has an administrative council and a secretariat. The administrative council is made of 1 representative per member state, and each representative has 1 vote. And it is presided over by ex officio by the president of the World Bank, but he doesn't get a vote. And then in terms of the secretariat, we have a secretary general, and currently we have 2 deputy secretaries general, and then the ICSID staff, and about 70. ICSID has 155 member states now, currently. The latest state to join ICSID was an African state, it was Djibouti. And by and large, African states are ICSID member states. The exceptions are Ethiopia, Guinea-Bissau, Namibia, which have all signed the ICSID Convention but have not ratified it. And then there is Angola, Equatorial Guinea, Eritrea, Libya, and South Africa, which have not signed the ICSID Convention. I want to talk briefly about the basis for rule amendment at ICSID. The ICSID Convention itself has never been amended. And amending the ICSID Convention requires a two-step process. The first being that 2/3 of the members of the Administrative Council have to decide to circulate a proposed amendment to all ICSID contracting states. And the second step of the process would be for all ICSID contracting states unanimously to vote to adopt a proposed amendment. So it's quite a stringent requirement for amending the ICSID Convention. Now, convention, we have two sets of rules, right? We have the rules that govern cases falling under the ICSID Convention, and we have rules that govern cases falling under the ICSID Additional Facility. With respect to rules that govern cases falling under the ICSID Convention, amending those requires a majority of 2/3 of the Administrative Council. So it's less stringent than the convention itself. And even less stringent is amending the rules that govern cases falling under the additional facility, because that only requires a majority of the votes cast, a simple majority. With respect to the current process, the current amendment process, it started in October 2016 when ICSID invited its member states to suggest topics for amendment. ICSID also invited members of the public to suggest topics for amendment. On the basis of the suggestions received and ICSID's own proposals, the Secretariat produced working paper number 1, which basically explains what the rules, what the proposed amendments are and why they're being proposed. And working paper number 1 was followed by a consultation meeting held in Washington, DC with member states. And we saw a huge participation by African states. As my friend Patience here can tell you, she has been one of the delegates representing Nigeria, but there were also other delegates representing other African states. Now, subsequently to the consultation meeting with the member states, we published a compendium of comments that were based on working paper number 1. Now, this cycle of working paper consultation meeting compendium of comments, it repeated itself until we published working paper number 4 and scheduled a 4th consultation meeting with our member states, only to cancel that meeting due to the COVID-19 pandemic. So currently, the ICSID Secretariat is finalizing working paper number 5 based on comments received on working paper number 4, and we hope to publish that in the late spring this year. The aim of the current rule amendments is to modernize, simplify, streamline ICSID's rules and use information technology to lessen the ICSID's environmental footprint, right? And use the lessons learned from hundreds and hundreds of ICSID cases to inspire this whole process. And I want to talk about 3 core objectives to the amendments. One is to reduce the time and cost of proceedings at ICSID. 2 is to expand the range of dispute settlement options offered by ICSID. And 3 is to continue to balance the interests of states and investors at ICSID. Now, in the next 3 slides, I'm going to discuss a proposed rule that exemplifies each of these 3 core objectives. So the first core objective that I spoke about in the previous slide is to reduce the time and cost of proceedings. We have all heard users say at some point or another that investment arbitrations are too long and cost too much. So expedited arbitration is one of the proposals that aims to address this concern head on. And what it does is that it looks at the 3 phases of the proceeding that take the most time, that last the longest, and drastically reduces the time taken in each of these 3 phases. So these 3 phases are the tribunal constitution process, the exchange of written pleadings between the parties, and the award drafting period at the end of, after the hearing. So under expedited arbitration, with respect to tribunal constitution, the parties have 60 days to complete the process. And the appointment of a sole arbitrator is the default unless the parties choose a three-member tribunal. Now, compared to the normal process, the tribunal constitution phase can take upwards of 4, 6, or even more months. So there's a drastic reduction in time there. Another phase that takes a lot of time is the exchange of pleadings. And here, under expedited arbitration, the parties would have 2 months each for the first round of submissions, and they'll be limited to 200 pages. And then they will have 40 days each for the second round of submissions. And there again, there is a page limit of 100 pages, right? Compared to the regular process, not expedited arbitration, parties routinely request 4 to 6 months each for the first round without any page limitation, and another 2 to 3 months each for the second round, again, no page limits. The third phase of the proceeding, which takes a lot of time, is the award drafting period. And the proposal under expedited arbitration is that the tribunal must render its award within 120 days of the hearing. This is 4 months compared to the normal process where awards can take months and months, you know, close to a year, or sometimes in some cases even more than a year. Now, a timetable this short requires compromises. So, for example, jurisdictional objections can be raised by respondents. However, they will not be considered in a separate bifurcated phase of the proceeding. They will be joined to the merits and considered together. So that's one of the compromises that has to be made. Expedited arbitration is practical in facilitating the access to international arbitration of small and medium sized enterprises. And it also may be attractive in cases that involve smaller scale claims, as well as cases with fewer factual or legal disputed issues. Now, the second core objective I had spoken about earlier was the objective to expand the range of dispute settlement options offered by ICSID. And here, the example I want to give you is Article 2 of the additional facility. So currently, under Article 2 of the additional facility, conciliation and arbitration disputes can be conducted where one of 2 situations is true. Either the dispute arises out of an investment, but the state party to the dispute or the state whose national is a party to the dispute is not an ICSID contracting state. Or the dispute does not arise out of an investment, but the state party to the dispute or the state whose national is a party to the dispute is an ICSID contracting state. So if one of those two conditions are met, you can have a conciliation or arbitration proceeding under the additional facility. And the proposal is, under the amendments, is to expand the scope of this article in two important ways. One would be that any state and the national of any other state could be parties to conciliation and arbitration proceedings under the additional facility, regardless of whether the host state or the home state are ICSID member states. And so this trend accommodates, or rather this proposal accommodates trends that are observed in some BITs, which basically offer dispute settlement under the ICSID additional facility where both parties agree. So it's just to accommodate that kind of trend. The second way in which Article 2 is proposed to be expanded is that the disputing parties themselves are no longer restricted to being a state or a national of another state, right? A regional economic integration organization can also now be a party to these proceedings, either as claimant or as respondent. And so the proceeding can be between a state or an REIO on the one hand, and a national of another state. And this is also because more and more we see REIOs signing international investment agreements in their own names, and these agreements have dispute settlement provisions. So to accommodate also that trend. The third core objective I mentioned earlier is the objective of balancing the interests of states and investors. And this is an objective that ICSID has always had since its inception. So the objective is not to balance, but to continue to balance the interests of states and investors. And the proposal here is a rule to notice third-party funding. The main obligation that arises under this rule is one of disclosure. And it is satisfied by a party filing a written notice indicating, number one, whether it receives third-party funding, and number two, the name and address of the funder. And that's it, right? The notice needs to be given to the Secretary General of ICSID, who then transmits it to any prospective or appointed arbitrators. As everybody, I'm sure, knows, third-party funding is becoming more and more popular. It's being used more and more by claimants and respondents to prosecute claims or defend them. And so the main reason for regulating third-party funding in ICSID proceedings is to avoid conflicts of interest between funders and arbitrators. And ultimately, this contributes to the legitimacy of the process. Those are the three examples that I wanted to discuss this morning. So I will stop here. Liz, over to you. Thank you.
Thank you so much, ICSID. It's so interesting to get a real nuts and bolts explanation of what this primary institution active in ISDS administration is actually doing. I'm sure there'll be some additional questions to you at the end. But now let us move on to Patience Okala, legal advisor for the Nigerian Investment Promotion Commission. Patience, I think that we've all looked at some of the work coming out of Nigeria in the negotiation and conclusion of recent BITs, and thought that's really interesting and possibly shows us a way where the field might develop. So over to you.
Thank you very much, Lizzie. I'd like to start by thanking the African Arbitration Association for the opportunity to share Nigeria's experience of reforms in BITs and the like. I'll first start by saying that, by sharing my screen first, and then trying to give a background as to what informed the reform process for us in Nigeria. And we just found that in addition to the fact that many states were getting slammed with ISDS awards against them, and I'm sure a lot of the participants on this panel, as well as the participants joining us, will be familiar with the process and ID case. But even before that was done, we found out that as a country, there seemed to be some disconnect between the quality of the BITs we were signing and the quality of investments that we actually were recording on ground. So it appeared that, if I could use an example, where we have arguably our greatest resource in Nigeria, which should be the Niger Delta area where we have the oil, also is where we have some of the greatest impoverishment in the country. So there's a lot of investment presence there, but you can't fish, you can't farm, the land is almost useless for the people. So it was very clear that there was a disconnect between the kinds of treaties we were signing and the quality of investments we were having on ground. And that is in addition to the fact that more ISDS cases were mounting at the time. It was based on that the government of Nigeria started a reform process of our IIA regime in 2015. And the objective of the process was to attract what we like to coin RIBS investments. And I will explain in further detail what RIBS means: responsible, inclusive, balanced, and sustainable investments. That was the policy direction and still is the policy direction of government for our IIAs as things stand now. The focus was to attract responsible, sustainable, inclusive, beneficial investments. We sought to also have BITs that will promote the sustainable development objectives of Nigeria, and will preserve our policy space and our right to regulate. We also thought it would be useful to balance the asymmetry between investors' rights and obligations, and of course, to expand the facilitation dimension of our treaties. This is particularly interesting because I work with Nigeria's Investment Promotion Commission, which is the key investment promotion agency of Nigeria. And in our engagements with investors on a day-to-day basis, you do not hear investors really complain about substantive provisions of the treaties. You don't encounter investors saying, there's no FECT, there's no indirect expropriation, no most favored nation. No, they complain about things that are basically facilitatory. They talk about access to investment information, licensing, and the like. So we thought to expand the facilitation dimension of our treaties and also to establish dispute prevention mechanisms. I'll speak a little more of what some of the mechanisms that we embedded in our new model, what they represent. And certainly to limit Nigeria's exposure to ISDS cases, because as things stood prior to the reform process, we seemed to have a more or less free for all, indication of ISDS for investors. So we started this reform process in 3 phases. And these 3 phases mirror UNCTAD's best practice for these reform processes. And we worked very closely with UNCTAD as well, in determining the structure of how we should proceed. So phase 1 of our reform process was for us to develop a new model BIT. A close look at our model BIT at the time showed us that there were some gaps. It was essentially tailored towards investment protection, which is excellent for investors. But sometimes we find that those old generation BITs meet only the profit expectations of investors, and they don't really speak to the developmental objectives of the home state. So we thought that it was useful to have a model BIT that meets those 2 expectations, both the expectations of the investors and of course the expectations of the home state. Phase 2 of our reform process was to modernize the existing stock of our old generation BITs. Phase 3, which is still work in progress, is to ensure coherence at all levels of our legal framework. So that's to ensure that both at the BIT level, at the level of our investment law, and of course our investment contracts, which are the 3 levels from which ISDS cases usually arise, we wanted to ensure that there was some coherence in the provisions such that we do not lose through our national investment law or our investment contract, the gains that we made, in the development of a model BIT. And I will now take time to show some of the provisions of this model BIT. This work was actually done by an interministerial committee. It's a committee that is chaired by the Federal Ministry of Industry, Trade and Investment, but Nigeria Investment Promotion Commission, Nigeria's IPA, that I work for, is the technical lead and leads negotiations of the BITs. We also have on that committee the Ministry of Justice, Ministry of Foreign Affairs, Ministry of Finance, Ministry of Budget and National Planning. Key economic ministries are also involved, in the process. So some of the highlights are, we decided to have a refined, enterprise-based definition of investment. Prior to now, we had an asset-based definition, but we thought it was useful to have an enterprise-based definition. We also circumscribed the fair and equitable treatment provisions, circumscribed our NT and MFM provisions as well. We inserted for the first time in our model BIT, temporary safeguard measures for transfer of funds. We also saw to it that we deleted the prohibition of performance requirements, deleted pre-establishment provisions, and then certainly to preserve our policy space and right to regulate, which is one of the pillars upon which the reform was centered on. And then we sought to balance the asymmetry between investors' rights and their obligations, and to improve the investment facilitation dimension, as I mentioned earlier. So in this regard, we came up with what we call a joint implementation committee. The joint implementation committee was supposed to comprise of representatives of the state parties. To do what essentially? Three main things. First, to ensure that the objects of the BIT were actually achieved. So the joint committee was to monitor the implementation of the BIT. In a number of clients, I'm sure in a number of developing countries as well, probably even some developed countries, who knows, we sign these BITs. Sometimes they're signed just for optics. The country's leaders travel and then we sign BITs, but we don't really get the benefits of the BIT. So the JIC was to ensure the implementation of the BIT. It was also to ensure an exchange of investment information, critical investment projects, strategic investment projects between the two state parties. And then finally, also to help with disputes de-escalation in the event of a dispute. So that was broadening the facilitation dimension of our BITs. And certainly we referenced sustainable development objectives, and we spoke about the promotion of CSR. We have provisions on anti-corruption, which was a challenge for us at the time. And then, of course, a lot of the innovative provisions we inserted reference global standards. We introduced mediation and dispute de-escalation mechanisms, and then the insertion of safeguards to ISDS provisions, such as the one that Anna had just mentioned. One of them is the exhaustion of local remedies, amidst others. It was on the basis of this new model BIT that Nigeria proceeded to conclude a BIT with Morocco. This BIT featured prominently in UNCTAD's 2017 World Investment Report. The innovative and reform-oriented provisions featured prominently as one that should be emulated as a new generation BIT. We're very proud to have concluded this BIT with Morocco, and it also speaks to the fact that where you have two like-minded countries that intend to have modernized treaties that actually also facilitate the economic development of the country in addition to the profit expectations of the investors, then this kind of BIT is possible. We negotiated a BIT with Morocco in 2016. We also negotiated the BIT with Singapore. The BIT with Singapore does not mirror in totality what Nigeria's new model BIT is, because we had commenced negotiations with Singapore 3 years prior to this BIT. So you see quite a number of relevant provisions in the BIT with Singapore, but the BIT with Morocco mirrors almost entirely Nigeria's new model BIT at the time. So after we finished negotiating this BIT with Morocco, the next step was for us to look at, we were done with looking forward in negotiation, but we were still stuck with the existing stock of old generation BITs anyway. And then we thought that it was useful for us to begin to look at modernizing our old generation BITs. The first thing we did was to come up with the map that I'm sharing with us. We tried to map 21 of Nigeria's 29 BITs at the time. And we drew inspiration for this from UNCTAD's World Investment Report of 2017, where it had mapped using 11 parameters, some key provisions, modern provisions, reform-oriented provisions of BITs. So we took it up a notch, and then we came up with 20 parameters. Those 20 parameters covered critical and reform-oriented provisions that we thought were useful to have in our BITs to give us the right quality of investment. And on the screen, you will see that there are a number of white gaps. So those white gaps show provisions that in our view were either critical or reform-oriented that were not reflected in the BITs. Where you see the green marks are where we had such provisions. So it was very easy to see, just pictorially, why the kind of BITs we were signing was not translating to the right quality of investment that we required. When we finished doing that, we went on a country-by-country basis to map the BITs of Nigeria, those in force, and the BITs that were concluded but yet to be ratified. Of course, with this new policy direction of government, it became very difficult to get Parliament to ratify any BIT that was not in sync with the policy of government at the time. And so we did that work on all our BITs, both those that were in force and those that were concluded. We use different parameters as I share on the screen. We crop, meaning critical and reform-oriented provisions, and then we scored them over 20, meaning the 20 parameters that we had. And then this work was done to determine the best next steps in relation to these old generation BITs that we were stuck with. Do we amend, do we renegotiate, or do we terminate? And we have started that process, engaging different treaty partners, and we're in the process of renegotiating a couple of these BITs, both those that are in force and those that have been concluded. We have engaged our treaty partners, and we're in the process of renegotiating not all, but some. I wish I could tell it has been an easy process, but that would not be entirely correct. The renegotiation is easier with some treaty partners than with others, but we're still pushing on. All right, and then phase 3 of the process will be, as I mentioned earlier, achieving coherence at all levels of the legal framework. So there is work ongoing on the review of the Nigerian Investment Promotion Commission Act, which is the main national investment legislation in Nigeria. It was relevant and useful to also ensure that that act was amended because it contained a lot of investment protection provisions, which had the same problems like our BITs. So having done work on the model BIT, we thought it was useful to align and ensure coherence between our investment law and the BITs. As Isds had mentioned, we're also looking at the multilateral reforms going on at the multilateral level. The AFCFTA investment protocol, of course, the modern BIT, a BIT that speaks to the sustainable development objectives of Nigeria, is the perspective with which we are consulting and negotiating. The preliminary talks on that, preliminary negotiations started, I think, 2 weeks ago. And that is the perspective that we are following. In the ICSID Rules Amendment process in UNCITRAL Working Group 3, it is still the same thing. We're trying to ensure that our policy objectives, as much as possible, as much as practicable, reflect our positions on all those 3 areas of reform. I think I'll stop here and then pause and take questions when the time for questions arise. Thank you, Lizzie.
Thank you so much, Patience, for that insight into this extremely considered and extremely sophisticated approach that you've adopted in recent years. There are a lot of questions popping up on all these different chat forum right now, so we'll gather those for the end. But before we do that, I am going to ask Lawrence Ngugi, the Registrar and CEO of the NCIA, to give us some insights into some of the activity, of which there is quite a lot that is taking place at the moment in Eastern Africa at a bilateral and a multilateral level on investment protection policy. Over to you, Lawrence.
Thank you, Alyssa. As I begin, I want to thank the Africa Arbitration Association for the invitation to take part in this panel. To thank Alyssa for the good work you've done in putting us together, and for my co-panelists for the excellent presentations you've already made. I'm privileged to be in a panel which has answered the call for diversity. I feel warmly participating in a conference where this is the case. I have been asked to speak on the recent developments in ISDS within the Eastern African region. I have done a fuller paper where I've looked at a couple of BITs. My intention this evening, as I make my presentation, is to look at a summary of some of the BITs that I have touched on in the fuller paper. So for the participants, as you get time, please visit the materials and you'll see the greater detail of these BITs. As I do so, I have looked at 5 BITs, one, Tanzania, China, 2013, Brazil, Ethiopia, Rwanda, Singapore, Burundi, and Turkey. And then I have looked at the recent events in Kenya with regards not to, strictly speaking, an investment protocol, but trade protocols with the UK and likely a US investment protocol with Kenya. As I begin, let me mention that although there may not be earth-moving events in the Eastern Africa region, and by this I define the territory between the DRC all the way east to Somalia, down south to Tanzania, and up to Ethiopia, there are nonetheless changes in the BIT landscape that are worth noting. If one asks the question, is the Eastern African region, as I have defined it, conservative or progressive? You are likely to find, as you look at these BITs, an element of conservatism and also a progressive movement in the new BITs. The duration that I have looked at is 10 years. That's the period 2010 to 2020. So BITs selected within that period within the Eastern African region. I may mention that as I begin, I realize it is the sub-region with the most recent states to join the New York Convention. So if you think about the year 2004 to the year 2020, we had 4 states within the region, that's Rwanda, Burundi, Somalia, and Ethiopia just last year, who became members of the New York Convention, and that's telling. Secondly, apart from Ethiopia, who is a signatory, but not yet come into force, the ICSID Convention, all the other states within the region are ICSID states. When you look at the BITs that I have examined, there appears to be a deliberate and intentional negotiation of BITs between these states and other states outside of the region, deliberate and intentional. I'll begin with the case of Tanzania, which in the year 2017 passed what is considered to be the 2017 triad, the natural wealth and resource laws, the first of which was the Natural Wealth Resources Review and Renegotiation of Unconscionable Terms Act of 2017. The second being the Natural Wealth and Resources Permanent Sovereignty Act of 2017. And the third one being the Written Laws Miscellaneous Amendments Act of 2017. What is worthy of note of these provisions is that it had a direct impact on BITs that would be negotiated by the Republic of Tanzania, although it did not affect the BITs 12 in number that were already in existence. Worthy of note is the Natural Wealth and Resources Permanent Sovereignty Act, of which Section 11 does make or prohibit proceedings in foreign courts or tribunals, thereby reserving the adjudication of disputes to the national state legal systems, that's courts and other statutory authorities. And this marks a clear departure by Tanzania in preferring domestic remedies as opposed to the ISDS framework. Most of you may have heard of the cases that emerged arising out of the passage of these laws. So apart from Tanzania, the other states do not seem to have a radical shift or departure from the ISDS structure. And we wait to see as the cases may arise with regards to these changes in Tanzania will impact the rest of the region. But interestingly, Tanzania also entered into a BIT with China in the year 2013, and with very interesting provisions that are not usual in other BITs, not just in the region, but globally. Some of the typical changes, at least to mention, one which I've also heard about Nigeria is a focus on sustainable development. However, what one notes is that it is provided for in the preamble, but not much is said in the text of the BIT. They've also provided for a broad definition of investment, but excludes claims for money for the sale of goods. And interestingly, claims for money from marriages and inheritance, which I would consider to be a very peculiar provision. In terms of the national treatment, it seems to have watered down the national treatment protection, allowing preferential treatment of nationals for the purpose of encouraging local entrepreneurs. With it also is a dispute settlement provision that offers investors 4 options and allows, worthy of note, for damages as well as restitution as discretionary remedies. So when looked at in totality, it does appear that the case of Tanzania is 1, unique, 2, bold, quite distinct from what is happening in the rest of the region. It has, in a sense, prohibited proceedings in foreign courts or tribunals, which is unlike what is going on in the rest of the region. Leaving the case of Tanzania, we have the BIT between Brazil and Ethiopia, and for this I'll put them together: Rwanda and Singapore, Burundi and Turkey. And what comes out of these BITs is each of them makes provision, apart from the BIT between Brazil and Ethiopia, for both state-to-state and investor-state settlement, dispute settlement framework. In the case of Rwanda, an interesting provision has been made whereby once the tribunal is supposed to render its decision or award on liability, that award or decision is transmitted to the parties, and the parties would within 60 days submit written comments to the tribunal concerning any aspects of the proposed decision or award. I find this, at least in the BITs that I have examined within the region, to be unique to the Rwanda-Singapore BIT. In the case of the BIT between Brazil and Ethiopia, it appears to be silent on investor-state claims, but makes provision for state-to-state investment dispute resolution. And then in the case of Burundi, it does make provision for investor-state settlement, dispute settlement. However, it also does recognize the place of local courts of the contracting parties as one of the avenues that parties can pursue in terms of enforcing their disputes under the mechanism. Largely, all these BITs provide for a cafeteria approach in terms of choice of forum for arbitration. The bodies identified are ICSID, additional facility rules, or under the UNCITRAL arbitration rules, and then other arbitral institutions or other arbitration rules as the parties may choose. They've also inbuilt dispute avoidance mechanisms, such as negotiation and consultation. And as I've mentioned earlier, in the case of Tanzania, have inbuilt exhaustion of local remedies as one of the avenues for settlement of disputes. Then I turn to the case of Kenya, recent developments. 2 instances. So one, the negotiation of the Kenya-UK EPA. The applicable BIT between Kenya and the UK is still the 1999 BIT. However, it might be interesting to note the current developments as the EPA between Kenya and UK were negotiated. It is now awaiting formal ratification between the 2 countries. One thing I would want to highlight, and which may inform future work on BITs in the region, if not a continent, is a greater role played by legislative assemblies for accountability and transparency. So with the ratification of Treaties Act, what we witnessed during the negotiation, and especially the last part of discussion of this particular EPA in the National Assembly, both in Kenya and the UK, is that it appears that the legislative assemblies are having a greater say in the negotiation of treaties. So it is no longer, it appears, it is no longer a bureaucratic exercise, which is negotiated in boardrooms, diplomatic circles, as was the case before. And this might inform the shape and form of BITs that may be concluded, at least in the case of Kenya and other states. It also means there will be greater scrutiny of agreements. So just as in the case of the example being given by Patience, although there is still no model law in the Eastern Africa region, there is already work going on towards developing a model BIT law, at least in the case of Kenya. And this might inform the changes that are taking place in the domestic law, requiring greater scrutiny of treaties by the legislative assemblies. And then there is finally the US-Kenya Free Trade Agreement that is under negotiation. For lack of a final document to look at, I compared the BITs between Uruguay, Rwanda, and Mexico and the USA. And from this, it is possible perhaps to deduce that some of the features of the BIT that may emerge from the negotiations between US and Kenya may very well mirror some of the provisions that are contained in the most recent BITs negotiated by the US. As I draw to the conclusion, one thing that emerges from this region is we have a perfect example of a situation where domestic legislation seems to be driving the negotiation of treaties. Greater scrutiny of agreements will be a thing of a mark of the future. There is also a clear indication in the BITs that have already been entered in the last 10 years that states are more determinate and intentional in the provisions which they are including in their BITs. And so as I conclude, the region also seems to be active in the AFCTA framework, and one wants to wait to see how the changes already taking place in the region, especially the case I pointed out of Tanzania, will inform the negotiation of regional BITs between this region and the rest of the continent, and indeed BITs between states in this region, inter-regionally, and across the continent. Thank you.
Thank you, Lawrence. There's clearly a lot going on in your region as well that will obviously feed into other broader continental developments. Fantastic. So thank you to all the panelists. We have a lot of questions that are actually backed up. I'm going to try and bundle them a little bit and turn to each of the panelists in turn. Let's start with you, Patience, if we could. And I'd like to ask you first what the effect has been of COVID-19 on the kinds of treaties that are being negotiated, both bilaterally and multilaterally. And then secondly, perhaps you'd like to say something in answer to a question that you've already addressed to some extent on the chat from Duncan about the requirement in the reform BIT of sustainability of investments, what exactly that will involve in practice.
Thank you, Lizzie. So in relation to COVID-19, COVID-19 brought to the fore the unprecedented risks of ISDS cases being filed on account of measures taken by governments to stem the spread of COVID-19. So we've had indications from, I believe it's Peru, where there's talk about an ISDS case being filed on account of those government measures taken. Of course, nobody had ever really anticipated a pandemic in the course of all the reform processes. So so there are two things. Now, we are already in the midst of it. what do state parties, what do both states need to do now in order to ensure that that risk does not become a reality? If the government are trying to avert a health crisis and had to take some steps, had to do lockdowns and the like, they will have to find a way of engaging treaty partners, as it were now, to help with some interpretation and to say probably ISDS probably should not apply to those instances where governments were responding solely to the COVID-19 pandemic. But going forward, I think it is something that treaty negotiators need to keep at the back of their minds in negotiating some of the provisions of the BIT in order to protect states from the repercussions of this kind of pandemic. In relation to what sustainability will mean, I tried to answer on the platform. And also just to pick up on the point that Lawrence had made earlier about our sustainable development objectives only being referenced in our preamble. Yeah, it was referenced in our preamble, but we narrowed down what we mean with the areas that we want to cover in the substantive provisions of our model BIT. For example, we have a provision on investment and environment. We have one on investment, labor. We have one on investment and health. We have one that deals with host communities. So it speaks to the details, or the granular details of what comprises sustainability in our own, from our own point of view. Environment is a key issue for us in Nigeria. You know, the example I gave in the beginning of our Niger Delta area, where we have the greatest wealth and arguably the greatest poverty at the same time. It's an environmental issue. There's so the large investment presence, but we have this environmental issue that we're yet to be able to deal with. Thank you, Lisa.
Thank you, Patience. Now we have a couple of questions about the African CFTA, which I'd like to address to both Lawrence and to Patience. Lawrence, perhaps you could kick off first and answer a question that's been posed about whether there is in fact a reference to the CFTA in Kenya's potential agreements, and if so, whether that will be subject to renegotiation once, for instance, an investment protocol is concluded. And Patience, once Lawrence has had his say, perhaps you could give us an idea whether the future investment protocol will affect or could affect Nigeria's future negotiation of BITs. Lawrence.
Thank you, Lisa. To my knowledge, given the little time that the AFCTA has been in place, I have not seen any agreement, at least in the recent 1 year, signed by Kenya that has made reference to the African trade agreement. And that's not a surprise given the duration of time when the convention came into force. However, I see no reason why Kenya, being a signatory to the convention, should not have provisions that apply the agreement in the investment dispute settlement mechanism. One of the acknowledgements that we, as African states, now have to contend with is African states are not just consumers of investments. They are now making investments. And so it is likely that we shall be seeing states insisting on some of the advantages and benefits that they derive from this trade agreement as investors. And no doubt, I believe that Kenya will take advantage of those benefits in its future agreements.
Thanks, Lawrence. Patience, anything to add from your perspective?
Yes, I will. And I'd like to speak specifically on the AFCFTA investment protocol. The preliminary consultations have started in earnest 2 weeks ago. And what I'm thinking about is whether it is possible for that investment protocol to, we wouldn't want a situation where it adds to the fragmentation of treaties. We don't want to worsen the spaghetti bowl of investment promotion treaties. And the initial discussions seem to suggest that countries might be open to having a binding document. For us to have a binding document, that means that the core principles, the core values, the big red lines for all countries have to be considered. If that is done, then probably there is a possibility of that replacing, the fragmented treaties regionally and the like. But there's also a problem of what if we come up with an investment protocol that is lower in quality than some of the BITs that have been signed bilaterally or even regionally? So the question is more, I wish I could give you an answer, but it would, ideally, it should be one that the countries are very comfortable with, such that we could actually begin to consider replacing all our inter-African treaties with that one investment protocol. It's still very much work in progress. Work starting to progress, not even in the heat of progress yet. But yes, it is something that could be considered. But that means we need to do a lot of work because different countries are at different stages of development. A number of African countries, like Lawrence mentioned, are capital exporting now, but there are still a predominant number that are still capital importing. And the interest, depending on whether you're capital exporting or capital importing, your interest shifts. So a lot of work we need to go into that for it to be a treaty that will replace the fragmentation that we already have. We're hopeful.
Thanks, Patience. Sticking with this idea of the spaghetti bowl, let me turn to you, Anna. Do you see consensus developing among the states that are represented in Working Group 3 or among blocks of states at the moment?
Thank you. Yes, very clearly, yes. There are, first of all, there is consensus on what are the concerns the states want to address. There is concern, there is agreement on the fact that they want this to be delivered in a package. There is agreement that they want this to be flexible, that they want this to be apt to apply to the existing treaties. And as Patience very rightly said, the idea is not to create yet one more fragmented element to a puzzle that never ends, but rather that to sort of bring everything together so that it works. And this is definitely a call also to the negotiators in the African region to make sure that you are in tune or in sync, which is with what is being done, because it would be most unauspicious if there were some advances in one direction and then something that went in another while we're all in the process of working. And as again, Patience said, it's a lot of work. It's a huge amount of work. And so we have to really make sure that we keep it on track. Having said that, as I mentioned in my presentation, there is agreement that we want this to end sooner than later. Where there is no agreement, at least by all, is on the reform options themselves and what state wants to go for what reform option. But what has been decided so far is that they would all be developed and put on the table under the umbrella of this broader delivery, multilateral delivery instrument, and that states would have yet another opportunity to choose whether they want or not to become members of a particular protocol to it, if they want to join the advisory center, if they want to join the appellate mechanism, if they want to join the investment court that the EU calls with its strong wishes, whether they want to apply only the procedural reforms that I mentioned. So all of this, I would say there is now agreement on the broader issues. There is agreement on how to develop the different reform options. What is not clear at this stage is what state wants to go with what reform option. But I think it's premature at this stage. And what is important is that everybody stays on to the negotiation of everything, because you don't know if at some point you may wish to join something, and it's much better to be involved in the deliberations and in the drafting and in the text than to be served something on a plate which has been negotiated by others. So that's, I would say, where we stand. but very optimistic. I haven't been that optimistic all the time, but right now I'm pretty optimistic.
Great, thanks, Anna. Staying with you for one moment, there was a specific question about the position of South Africa, which of course has largely withdrawn from the current system, terminated most of its BITs. And the question is, how would the current ISDS reform initiatives find application in jurisdictions like South Africa that have done exactly that?
Mm-hmm. Well, they are participating very actively. They have submitted a number of papers. They intervene and propose and discuss at every working group session. So the mere fact that they're very engaged is that they see some benefits for South Africa in being part of the discussions and also in what is going to be an outcome. Because as you rightly noted, they have terminated some of their bids, not all. There are regional efforts underway. There is a different change in the hat. South Africa is now mostly capital exporting. So, you know, that also changes the perspective, or at least makes sure that you want to protect your rights to be involved and to choose when the time comes.
Thank you, Anna. So getting a little bit more granular, I'm going to turn to you, ICSID. There are a couple of very specific questions that have come in. The first is about third-party funding. So in the third-party funding amendment, can an investor be compelled to disclose the details of the third-party funding arrangement?
So under the rule, the obligation, like I said in my presentation, is an obligation of disclosure of whether third-party funding is being received and the identity, name, and address of the funder. And that's basically what the rule requires. So the details of the funding arrangement are not required under the rule. That said, the tribunal, if it decides that it is necessary, may require the disclosure of additional details about the arrangement.
That's clear. Another question to you, ICSID, from Emeka, about the pagination limits for disputing parties' pleadings, whether those include the annexures, and if so, would it amount to a denial of a fair hearing if a disputing party doesn't have the space to put forward their case?
Thank you. This is another great question. So, and it's about due process. It's about the integrity of the proceedings. And so the answer is that expedited arbitration is an opt-in. It's not a requirement. It's not imposed on the parties. So the parties themselves have both to agree to have this proceeding. And once they agree, then expedited arbitration applies. And they can opt out of it at any time by agreement, or if one of the parties simply doesn't want to continue. And so if they opt in, it is with the understanding that they would want to abide by this page limit. It is with the understanding that the case that they have before them really lends itself to expedited arbitration, because not every investment arbitration case will lend itself to expedited arbitration. Because so with all these understandings in mind, I think the parties would make an informed choice whether expedited arbitration is appropriate. And if along the way they discover it isn't, then they can just opt out.
Excellent, clear. Right, now bearing in mind we only have 7 minutes left for this panel, I think I'm going to go to a question that is quite general and could be well addressed by all the panel members, one by one, from Wairimu Karanja, who says, what do you think are specific ISDS reforms that will have tangible benefits for African countries as they try to balance investor interests with national interests? And I think I'm going to ask Patience to kick us off on that.
I think that's an excellent question. What do I think? Start from the scratch. Before we deal with ISDS reforms, ISDS actually emanates from the substantive provisions of the treaties that African countries are signing. So I believe that the reform process should start from the substantive provisions that the treaties that are being signed. There's a need for us to reform the text of those treaties because there's no magic about it. If the text of your treaty says one thing, you are bound by it. There's need for that reform. Secondly, I think that African countries should also focus on dispute de-escalation or dispute prevention. There's need for some kind of mediation. Not every dispute should end up in arbitration. So we should be looking at creating investment ombudsman, something that Nigeria is trying to do as well. We should be looking at joint implementation committees. Experientially, we find that when investors have difficulties with agencies of government, they come to NIPC. They come to NIPC because NIPC is the investment promotion agency. They're looking for people to solve the problems, not necessarily somebody to take them to international arbitration. And then also there is the proposal about exhaustion of local remedies. Probably African countries, I don't know whether we can actually exhaust local remedies, but there should be some kind of recourse to local remedies. But dispute prevention and the text of our treaties are paramount. We have to deal with those.
Thanks, Patience. So dispute prevention and the text of the treaties. What about you, Lawrence? Anything you would pick out?
I think the examples I've given illustrate some of the challenges that states will have to confront. In the case of the BIT between China and Tanzania, one observation was that although China would be regarded as a stronger party in terms of entering into negotiations with Tanzania into the treaty, it would appear it did not assert its perceived superiority, if you'd like to call it that, in terms of negotiating this treaty. And therefore, some of the provisions that found their way into the treaty seem to suggest a kind of compromise. So it may appear to be a question of statecraft. What posture does the state have? What informs its local domestic policy in terms of investment? What things, as Patience has said, where do we draw the red line? And the fact that it is now very clear there is a determinate, intentional negotiation of treaties. The point I made about the involvement of local legislative assemblies in scrutinizing treaties has taken away the open check, so to speak, of delegations to bind states into agreements which have not been scrutinized, or at least not accountable to the larger public. In that case, therefore, it appears that one of the things to look at is what informs domestic policy, what is the process of ratification of treaties, that in itself, before we even deal with what are the substantive provisions, because then the state will come to the table with an informed position to negotiate with its counterparts across the globe.
Thank you, Lawrence. Anna, do you have any thoughts on that issue?
Yes, I would say that in so far as the package of reform is a comprehensive one, I think that countries from the African region would be well advised to take the entire package, because it's the entire package that is going to be the most protective of the state in order to rebalance treaties that are very often considered as unbalanced in favor of investors. So I think that the more, the better. Now there are of course aspects, as Patience was saying, of dispute prevention, where we're working on, as I said, a model law that will then easily be applicable by the states and enacted so as to set up the institutional framework that is necessary for dispute prevention or access to more mediation. So all of these elements form part of the reform package, and if you really want to get the most out of it, then go for everything. Don't be too selective, especially when you know what your interests are and what your priorities are. What is it that you want to protect? Then I would go for the entire package.
Thank you, Anna, with that exhortation. I am being exhorted to stop this panel, I'm afraid. So there are a number of other fantastic questions that have been asked. I think you can continue to actually ask those in the Whoever app, and the panelists will do their best to actually share them. From me, thank you to all 4 excellent panelists. I think it's been a great discussion today and a really excellent introduction to the next session on ISDS, which will focus more on African perspectives on the process, and will start in exactly half an hour from now. So thank you again, and thank you to all the participants for your interest and your participation. Bye-bye.
Thank you. Bye-bye.